Hello, this is Heidi Meyers, immigration attorney, and today we're going to talk about the recent Supreme Court decision this June 2021 in Sanchez versus Mayorkas. In a unanimous decision authored by Justice Kagan, the Supreme Court held that although temporary protected status is considered to be maintaining lawful non-immigrant status, it is not considered to be an admission for purposes of adjustment to permanent residency. So this is a really important decision for those of you who are in temporary protected status regarding, whether or not you're going to be eligible for your green card, whether or not you're going to be eligible to adjust to permanent residency. Now, what is temporary protected status, or TPS? According to the Immigration and Nationality Act, the Attorney General has the authority to designate certain countries for TPS, where there's an armed conflict, where there's earthquake, hurricane, epidemics, other natural disasters. So once a country is designated for TPS, the nationals of that country are eligible to apply for TPS status and for work authorization. These designations are generally for an 18-month period, and then the government has the authority to decide whether or not to extend the TPS. So many of the countries that are now designated for TPS were designated quite a long time ago. So if you arrived in the United States after the designation date, you are generally not eligible for TPS. So, for example, El Salvador was designated for TPS on February 13th, 2001. So that means anyone from El Salvador who arrived after that date is generally not eligible for TPS. So only if you arrived on or before that designation date. In this example, we're using El Salvador of February 13th, 2001. Now, the case Sanchez versus Mayorkas involves Mr. Sanchez, who arrived in the United States in 1997. So we're talking about someone who's been living in the United States for more than 23 years. So he came to the United States in 1997. In 2001, he became eligible for temporary protected status, and he received TPS, and he was maintaining TPS status for about a decade and a half when he then applied for adjustment to permanent residency. And so in his case, the Supreme Court decided that although he was maintaining lawful non-immigrant status because he had the TPS, since he had entered the United States illegally, and since under the statute 8 U.S.C. section 1255, there are two separate requirements. So one requirement is that you were inspected and admitted or paroled by a U.S. immigration officer, and a separate requirement is that you are maintaining a lawful non-immigrant status. So the Supreme Court held that TPS, yes, it is considered to be maintaining a valid legal non-immigrant status for purposes of adjustment, but it is not by itself considered an admission. So you meet the second requirement of the statute 1255 of maintaining valid legal non-immigrant status, but you don't meet the first requirement, which is that you were either inspected and admitted to the U.S. or you were inspected and paroled by a U.S. immigration officer. So the first requirement is you have to present yourself to a U.S. immigration officer at a port of entry and either be inspected and admitted or be inspected and paroled. So while the TPS gave you that legal non-immigrant status, it didn't give you the lawful admission or parole. So that was basically the holding of the Supreme Court. And so it's tough in the sense that many people who have TPS, as I said, have been living here for a very long time, maybe decades. So if they did not enter legally, then they're not going to be eligible for adjustment to permanent residency. However, it did clarify that TPS status, yes, is considered valid, legal, non-immigrant status, and it does qualify for adjustment to permanent residency if the individual, like I said, was previously inspected and admitted or paroled by a U.S. immigration officer when they came to the United States. So this is going to put a lot of people who have TPS in a tough spot because they've been living here for a very long time and they might have become eligible for adjustment to permanent residency. Say their spouse is a U.S. citizen, or they have U.S. citizen children who are now all grown up and who can petition for them, or they're the parent of, they're the parent of a U.S. citizen, whatever. Okay, so it puts a lot of folks in a tough spot. Justice Kagan did point out in her opinion that legislation currently pending in Congress, the American Dream and Promise Act, would provide that those folks with TPS would be considered to have been making an admission for purposes of adjustment to permanent residency. So the justice pointed out in the opinion that yes, there is a legislative fix, and basically we have to get Congress to change the law. So this will affect many people because right now, the countries that are designated for TPS as of right now are Burma, Myanmar, El Salvador, Honduras, Nicaragua, Somalia, South Sudan, Sudan, Syria, Venezuela, and Yemen. So this decision is going to affect a lot of people. I'm sorry, I forgot. Haiti and Nepal also are on the list of those countries that have TPS. Like I said, many people who are from these countries but who arrived after the designation date are not eligible for TPS, and many of these countries were designated quite a long time ago, except for Venezuela, Burma, Myanmar, a couple of others. So anyway, a decision with big implications. It does not affect people who are granted asylum and who are now applying for adjustment to permanent residency. That is because the statute, the section of the Immigration and Nationality Act under which folks who have asylum apply for permanent residency is a separate section of law from 8 U.S.C. section 1255. So if you have TPS, you need to qualify for adjustment to permanent residency under 8 U.S.C. section 1255. And if you don't have that lawful, inspection and admission or parole, you don't qualify. However, if you were granted asylum, this decision does not affect you because people who are asylees and who are applying for the green card adjust under a separate section of the law, which is 8 U.S.C. section 209. So it's 8 U.S.C. section 209. The first part of it, subsection A, is for refugees who are adjusting, and the second part is 209, subsection B, which is for asylees who are adjusting. It's a separate provision of law, and it does not have that requirement of admission. Okay? So if you have asylum and you're applying for your green card, this decision does not affect you. All right? So no worries if you're an asylee. Now, another very interesting thing about this decision is that it was a unanimous decision. And if you've noticed what the Supreme Court is doing lately, they've been issuing many unanimous decisions, which is a little bit surprising since you have all these ideological differences on the Supreme Court. But it's also very interesting because I think probably all the justices are very concerned. Number one, they don't want the Supreme Court to be damaged as an institution. They don't want to be viewed as some political appointee that's just under the thumb of a particular president, and maybe the justices are a little alarmed about these proposals to change the number of justices on the Supreme Court or set term limits. I'm not expressing an opinion on whether there should be term limits or whether we should have more justices. But anyway, I just thought it was a very interesting situation that the Supreme Court, all the justices seem to be trying to band together, and they seem very interested in preserving the integrity of the Supreme Court as an institution. All right, folks, that's it for today. Thank you very much. And if you have any ideas for videos that you would like to see, please let me know in the comments below. Again, my name is Heidi Meyers, Law Office of Heidi J. Meyers, 11 Broadway, Suite 925, New York, New York, 10004. My number is 212-791-4007 or 646-508-5225. And my email is heidimeyerslaw@gmail.com. And don't forget to like this video and subscribe to my channel. Thank you very much. Bye-bye.